With that, I will now call the first case, 120436, in the matter of the joint application of Westar Energy, Inc. and Kansas Gas and Electric Company. Counsel?
Good morning. May it please the court, my name is David Bender. I appear for petitioner appellants Volt Solar and the Sierra Club. With the court's permission, I'd like to reserve 5 minutes for rebuttal.
5 minutes is reserved. Thank you.
Thank you, Your Honor. And this case originates as a rate case before the Corporation Commission. A review was sought of a rate case order at the Court of Appeals. A decision issued from the Court of Appeals in April this year, and the case arrives here at this court on a petition for review of that decision. The rate-making order at issue here imposed a new rate with a new rate structure for customers who take service from Westar and have their own solar generation that fulfills some of, but not all of their electricity requirements at their home. 40 years ago, the Kansas legislature adopted statute section 66-117D. That broadly protects customers who rely on renewable energy at their homes from higher rates and charges or any other prejudice or disadvantage imposed on them as because of their use of renewable energy. The federal government also extended protections around the same time for customers who rely on renewable energy. Neither the state statute nor the federal regulation has been changed. It hasn't been rescinded. It hasn't been amended. Nevertheless, Westar's 2018 general rate case, the case at issue here, imposed a rate called RSDG. It's the designation for the rate. That rate imposes higher charges for customers who use solar power on their homes compared to what those customers would pay if they weren't subjected to that. That is, if they were left in the residential rate class and paid the rates applicable to all residential customers. Court of Appeals opinion upheld that rate, but did not uphold the rate because it complies with 117D. Rather, the Court of Appeals decision upheld the rate based on a holding that 117D is displaced. There's a conflict, the court found, between 117D and another statute adopted some approximately 30 years later, 66-1265 sub E. The Court of Appeals interpreted that later statute as, quote, almost impossible to reconcile with 117D. And based on that finding of inability to reconcile it, the court decided that the more recent 1265E should apply. Absent that irreconcilable conflict, 117D, 66-117D, would prohibit the exact type of rate we're dealing with here, the higher rate for customers who rely on solar power.
Counsel, can we assume that it is a higher rate based on the KCC's findings and the argument of your opposing party?
We can.
What evidence do we rely on the record for that?
Sure. There's evidence. The only evidence in the record is evidence from Sierra Club and Volt Solar's witness, who calculate. So let me back up. The relevant comparison is what do these customers pay under RSDG versus what would they pay under RS? That is, if they weren't treated differently, right? So that's the relevant counterfactual we need to look at. The only calculation under that comparison was done by Ms. Yowick, Sierra Club and Volt Solar's witness. And what she did, unlike any other witness, was she took the actual loads and usage data for customers with solar, ran that against the RSDG rates, and then ran it against the RS, the, say, regular residential customer rate. And that difference is the amount of the higher rate. In addition, I'd point out that contrary to some representations in the briefing, the entire point of the RSDG rate was to charge these customers more. If there was no higher charge, we wouldn't be here.
You're opposing the Westar and KCC, as I understand it, argue that the effect might have been to charge more, but the point was to recover or resolve what I'll call the free rider problem, or the problem of renewable energy customers not paying their full share of sunk or fixed costs of the grid.
Right. So I think that's two issues, Your Honor. Right. One is, are they treated differently because of their solar, and the other is, why, and what was the rationale? And what 117D says is they can't be charged more. There's no exception in there for if there's a rationale.
But that does beg the question of, again, as I think Judge Lieben was driving at, are they really being charged more?
Well, they are being charged more than a residential customer without solar who has the same usage. So if we do that,
They're being charged more for the electricity.
they're being charged more for the electricity.
But
right.
the counter argument, as I understand it, is they're not actually being charged more. The reason they're paying more for the electricity is because they're actually paying less for the fixed costs, and so it balances out. That's at least my rudimentary understanding of the argument.
That's roughly my understanding of the argument, but as I guess pointed out, the evidence here is, if the comparison is how is the solar customer treated under RSDG versus how would they be treated for that same amount of consumption under the RS rate, which is the same way to say, what if a residential customer without solar has the same usage, uses the same amount of electricity from the grid? Are those two customers being treated the same? And the evidence is no.
Well, clearly they're being treated differently.
Correct.
I think it's a slightly different question to ask whether or not they're being prejudiced or charged or discriminated against effectively.
Sure, and we deal with this primarily under the federal regulation that applies here. And the federal regulation says customers need to be, essentially, if you treat a customer with generation differently, that rate has to meet essentially two criteria, right? One, actually, it has to meet three criteria. One is it has to have a cost basis, which is not a basis for a challenge, for the petitioner's challenge here. The other two are, it needs to be based on system-wide costing principles, and it has to be charged to the same extent that it would be charged to a customer, another customer, a non-generating customer, who has the same amount of usage. And this rate fails those two criteria. And
How do you interpret system-wide?
Equally across all customers. I mean, and I think what the regulation...
I believe the opposing argument is that we have some customers that in fact cost more. So system-wide, we're applying the same cost principle to all groups, but a group that costs more can be charged more based on a consistent system-wide cost principle.
So as I understand the argument, and as I understand the evidence that the commission relied on, which was witness glass, these customers have the same demand cost. So it's not a difference in cost that we're dealing with. We're dealing with, at most, a difference in revenue. How much revenue they bring in under a kilowatt hour charge compared to some other customer who uses more. And what a system-wide costing principle says is a couple of things. One is it says when you have usage-based data, that's what a cost of service study is, and you're deciding how we're going to design a rate to recover the revenue for that customer, we have to apply the same policy to the customer with generation that we apply to the customer without generation. Customer without generation is able to reduce their payment towards what's being called fixed costs in this by using less, right? If I install LED lights, if I unplug the second fridge from the garage, I'm using less electricity, I'm paying fewer kilowatt hours. If I do that, I contribute less to fixed costs.
If we take the utility argument sort of on its face, isn't part of the problem here that the billing structure itself is flawed in that it seeks to recover fixed costs through a per unit sale? That seems to me to be a fundamental problem.
To the extent, I mean, there is a reason for collecting costs through kilowatt hour charges, but to the extent that we find a flaw with that, that's a flaw that applies across the entire class.
Right,
That's
and
true.
if we take the argument at face value, there are other ways to recover fixed costs that would arguably at least be more equitable, i.e. just charge every customer a flat fee to be part of the grid.
That is a different costing principle. And what we would do then is we would say, well, if that's the costing principle we're choosing to apply to design rates for Westar, that needs to be applied system-wide. We have to apply it to the residential customer without solar panels as well as the customer with solar panels. Problem, the way that this rate trips over the federal regulation is it says that's a policy we're going to apply. We're going to collect these costs, something other than a kilowatt hour charge, from solar customers through this demand charge, but we're going to.
Well, let me rephrase the question. If Westar wanted to recover its what it calls fixed costs, couldn't it do? Is there any impediment in the law to it doing so by charging the same amount to every customer,
No.
separate from the sale of electricity?
So if the hypothetical is, can Westar create the RS rate, the one for other residential customers, and say
Yeah, just apply across the board.
$85 charge no matter how much you use, and solar customers pay that, and non-solar customers
Right,
pay
anyone who hooks up to the grid pays that.
that. Right. So what I can say is that does not violate 117D.
It wouldn't seem to me to. And I guess my follow-up question is, do you know, I mean, why hasn't that rate structure been adopted? Maybe you
I don't
can't
know.
answer that question.
I mean, what I can tell you, and I see my time is up, if I can
You can continue.
finish the answer. What I do know is the kilowatt hour charge was developed for other reasons, to send a price signal to use less electricity, because even though it collects less of the fixed costs, we're going to impose more of those through a kilowatt hour charge to incentivize people to use less, which in the long run saves everyone.
And isn't that exactly what you're arguing? Is that, look, if you want to make a rate structure that incentivizes customers to use less electricity, don't punish people who use less electricity.
Well,
It seems to me to be the
certainly-
fundamental heart of your argument.
Certainly don't single out one subset of customers and decide that costing principle is no longer going to apply to solar. We're only going to apply it to other people who haven't yet taken steps to reduce their electricity usage.
Is it essentially your position that any differentiation between those that generate their own electricity through solar or other means and those that don't is violative of 117D?
No, that's not. the position.
And how can it be differentiated and not violative of that?
Sure. So what we would do is we just compare the text of 117D, which says higher rates and charges or prejudice or disadvantage. So it could be less, right? Or as we pointed out in the reply, a minimum bill, for example, could be applied, but if it's not prejudice, if it's collecting what they would otherwise have paid, but through a separate charge, it doesn't run afoul of the statute. So it's not a difference per se, not every difference. It's the difference that violates the statutory language, which is higher rates and charges or some other prejudice or disadvantage.
Counsel, I want to ask another question about 117D on that second part, the prejudice or disadvantage. One of the things that's going on here is that for all other residential customers, they can either use the new system of pricing that the solar people are forced to use, or they can keep the current system of pricing. If both options were available also to solar users, would there be a violation of 117D?
I don't believe so.
So one of the ways in which you're claiming there's a disadvantage is that everybody else has an option, but the solar owner is forced to use only the new system.
I believe that's most of it. I mean, it's that they're forced to use the new system, and there's other parts. The new system collects more money from them, and has some, because of the way it's structured, has some issues with the ability to respond to that price signal. So in part, yes. I mean, giving everyone the same options for the same rates satisfies it. On the other side, forcing solar only solar customers to use one option and not have the other option violates because it charges more and has a rate structure that's prejudicial.
Do you agree with the Court of Appeals that the two state statutes conflict?
I do not, Your Honor. And I would say they don't conflict based on the plain language of the state statutes. 117D says no higher rates or charges, no other prejudice or disadvantage. 165E says as to a subset of customers called customer generators, which are customers who use net metering, it's a whole other program with its own intricacies. Those customers who connect after 2014 can be charged a minimum bill, time of use rate, or other rate structure. It says nothing about exclusivity. To get to the prior question, right? Time of use rates, minimum bill could be charged to everyone. That complies with 1265E and with 117D. In addition, even if a customer with solar is charged time of use rate, minimum bill under 1265 sub E, if those rates are set such that they don't collect more money than would be collected from whatever the default rate is, that also does not violate, therefore would not conflict with 1265E. So put another way, 117D says no higher rates or charges, no other prejudice, right? As long, there's no conflict with that unless 1265E says clearly you may charge more or you may impose some other prejudice. 1265E doesn't say that. And
It seems to me that, at least arguably, 165E is, I'm sorry, 1265E is talking about rate structure as opposed to amount.
Correct.
Is that a fair way to look at it from your perspective?
That's right. I mean, on its plain language, it says rate structure. And the two examples it gives are rate structures. In the previous section, sub D, the legislature carves out rate structure is different from rates, which is different from charges. And it talks specifically about rates, it talks about rate structure, it talks about monthly charges. So then when the legislature says in E, rate structure, that's omitting, right, rates or charges.
So as I understand it, you're saying reading these statutes in harmony means that there's flexibility in what rate structure is imposed. And in fact, a different rate structure might actually be able to be imposed on these customers so long as it doesn't result in a discriminatory or prejudicial cost.
Right.
Is that a fair statement of your position?
Right, so to harmonize, we just say, is there a way to read 1265E so to do something other than, and it doesn't matter for this purpose, this construction, what that is, as long as it's not authorizing what 117D explicitly prohibits. And we've identified a number of constructions consistent with the language, consistent with the structure and the history that the court can apply, give meaning to 1265E while not interpreting it to create a conflict with 117D. My time's well over, so unless there's other questions.
Thank you,
Thank you.
counsel.
May it please the court. I'm Brian Fedotin, General Counsel for the Kansas Corporation Commission. Good morning. The Sierra Club and Vote Solar are asking you to vacate the RSDG rate, which would force residential customers to subsidize the cost of serving distributed generation customers to a much greater extent than they presently do. Cost causation is the overriding principle in rate design.
How are they subsidizing?
Sure. That the solar customers, or the DG customers, I'm sorry, I'm using terms interchangeably, they only pay, under the challenge rate design, they're only paying about 70% of their capacity cost. And so somebody has to make up the difference, and it's the remainder of the residential customer.
Why are they only paying that smaller percentage? Is my understanding is it's because they use less electricity?
They use the difference between the two-part and three-part rate design. Everybody pays, all residential customers are paying a customer charge, which is the set monthly fee that you have for being connected. Then there is a volumetric charge, which is how much you use. And then the third one, component of the rates that the DG customers are paying is essentially a time of use rate, and which is specifically authorized by KSA 661265E. And basically, as the Sierra Club notes on page 2 of their supplemental brief, DG customers pay a premium for electricity they use from 2 to 7 p.m. On the weekdays. So that's the time of use, which again is explicitly authorized by 1265E.
Just back to my,
Sure.
it might just because I have a rudimentary understanding of this.
So do I, so we should be on good terms.
I'm trying to, you started your argument by saying, and I understand this
Sure.
to be the heart of your argument. Look, we need this rate structure because I'll call them quote unquote ordinary customers
Sure.
are being forced to subsidize the customers who use a solar system.
Right.
And that's been the theme of the utility and the KCC throughout. And I am trying to figure out how that's actually true on the ground.
Sure.
How are they subsidizing?
Sure, because since they don't use much electricity, but there are times where with cloud cover, whatever, they suddenly need to use electricity, their usage rate is inconsistent. It makes it
So it has to do with their usage.
the frequency of it. And remember, the electrical grid is built for capacity. So
So my follow-up question then would be, if there was a customer who had identical or more or less identical usage, but was not a solar customer, wouldn't that customer be in exactly the same situation as the customer that had a solar generation?
if such customer existed, but I don't know that such customer does exist, because you're talking a really infrequent usage pattern. You would have to be somebody who almost didn't. You would not have to. You'd not be using your primary residence very often, and you'd come in and you turn the lights on at 2 o'clock, turn them off at.
But as a matter of
2:15.
principle, there's no distinction. In other words, from an economic perspective, if your economic argument is correct, it applies equally, because it's purely based on usage, not based on method of generation.
Correct. Yeah. The rate design is designed to.
How do we
cost
square
causation.
that with the fact that the rate design doesn't capture those customers?
Doesn't capture. I'm sorry. Doesn't capture.
It only applies its different rate
Right.
to customers who have solar generation or renewable generation.
Because they have unique usage characteristics that the rest of the residential class does not have, and so they do not pay the cost.
Is there anything in the record that supports that factual assertion?
that they don't pay their
No, that there's no other customer that has similarly situated based on usage.
I believe that the expert testimony in the record of the rate design experts say that I don't know if they say that there's no customer, but I think that they make it clear that it's a hypothetical, and there probably aren't many, if any, customers.
These would be customers who don't use much electricity between 2 and 7 p.m., right?
Are we talking about residential
Ones that would be similar to the solar customer that you're saying puts an unusual demand on the system sometimes.
Well, 2 to 7 is the peak usage for the system in general. It would be people that used energy sporadically and unpredictably from the 2 to 7 period. So it's not just somebody like me who's at work during most of that time who doesn't use any, because I'm consistent and easy to measure.
So it could be a shift worker like a firefighter that's working some days for 36 hours straight and then home for 36 hours straight or more.
Yeah, and even more unpredictable than that. I mean, this is again, the solar panel is working, and so you have 15 minutes where you're generating electricity and you're not using the grid, and then the cloud rolls in, and you need to pull.
How does sporadic energy use create higher costs to the utility?
It's all about capacity, and a utility needs to be. Utilities are built for peak, so if everybody in the system turns a light on at the same time and everybody plugs their Christmas lights on the same time, that the system can handle it. So there are costs associated with.
Are you saying that, again, in a very rudimentary sense, so I can understand
Sure.
it, are you saying that this pattern of energy use creates wasted electricity? Because the utility has to make more than it actually can sell?
It has to have it at the ready, whether it makes it or more. But yes, I mean that's the whole way.
Is it being wasted? Is it going unsold?
It's. I guess you could say that. Yes, it's available because the system needs to be. If
My understanding is it's being sold anyway. Is that wrong?
Yeah, it's not necessarily being sold because again, if the solar customers are able to generate their electricity at that time, they're not buying any off the system. Yet the utility still needs to have the capacity available in case something happens with the solar panel or that customer is not able to draw in to self-generate. So the utility is expending the money to have that capacity available, whether or not the energy is there, where a typical residential customer uses more electricity and has a much more predictable pattern of
Predictability
usage.
drives utility costs down.
Yes.
As a general principle, that makes some sense to me. Is there any way to, wouldn't there be a way to design a rate structure that changes the costs based on actual usage as opposed to whether or not somebody generates their own electricity?
I mean, you would have to probably raise rates, and it wouldn't. You still have, and it would not solve the subsidy issue because even if a solar customer uses almost no electricity during the billing cycle, you still need to have the capacity available in case that they can't self-generate.
Sure, and I'm trying to drive at the question, why can't a rate be designed that's non-discriminatory, that applies to everyone the same,
Well, I mean,
based on usage?
Sure. Well, it probably wouldn't be based on usage. I mean, you could do things like the first component of both rate structures is a customer charge, which is a flat fee. I mean, right now it's around $18. I mean, you could increase that substantially. That would be unpopular. It would harm everybody. It doesn't help people based on usage. I mean, that would be one way to do it.
Are you saying this one was chosen because it had fewer people involved and therefore was more popular with the people that didn't have to pay the extra charge?
No. What I'm saying is if you did something really simple and you just increased everybody's customer charge regardless of usage, that would be highly unpopular because everybody across the board is paying more and it doesn't address the problem. That's rate design is very complicated and there are a lot of moving parts, and so I think it would be difficult to design something on usage that.
Let me just give you a hypothetical.
Sure.
It seems to me you could create a rate, it might be bad for all sorts of other reasons, that simply charged a higher rate for electricity delivered during a certain time of the day. And you could apply that rate to everybody. And it might negatively impact solar users because they're the ones who more often buy electricity during the times when they're not generating their own. But it would still be a rate that applied to everybody. Wouldn't it?
I mean, so you're talking about designing a time of use rate that applies to all residential.
There's just lots of
customers.
ways, it seems to me, to solve the economic problem which I sympathize, I understand the economic problem that the utility is raising, but it seems to me that you've sort of shortcutted the answer to that by just saying, well, we're just going to charge these people who generate their own electricity more.
Sure, Your Honor, that still ignores the cost causation principle, though, because, again, the solar customer usage is so inconsistent and infrequent that I think for the utility to make its revenue requirement, I think the time of use rates would have to be extremely high, and I don't know that you could do a rate design that is so heavily dependent on time of use and still.
Is the only reason you couldn't do it because it would be highly unpopular?
I think that's a factor, but I think the bigger reason is just more impractical, that it's much harder to estimate revenue and all of that, and have the utility still.
Doesn't the utility know? I mean, isn't that data collected by the utility when electricity is being used by different customers?
It is, but the unique nature of solar customers, like I said, is they are so sporadic in use.
But I'm just saying the utility has the data.
I would think they do. Yes, they should.
Okay.
On the point about the record establishing that the solar energy's users are prejudiced or disadvantaged by the structure, do you agree with Mr. Bender's statements about the record and their expert being the only one to directly address that?
No, I don't, Your Honor.
And could you respond to that? So why?
It's. Let me look at my notes here. Trying to see. Sorry, I've been thrown off because I didn't need to bring my outline this morning. No, I believe that in rebuttal, Westar's witness, Mr. Faruqi, I don't have a specific page site, but I believe in his rebuttal testimony he addresses it. I commissioned staff witness Dr. Glass may as well, but I don't know off the top of my head. I don't have a page number, but I'm relatively certain in Mr. Faruqi's rebuttal testimony, which is in the record. It's rebuttal directed at Miss Yozwiak's testimony.
I'm struggling here, so let me try
Sure.
the hypothetical that keeps interrupting me listening to you. 'Cause
Sure.
I keep processing it, and then you just tell me where I'm wrong. Got 3 customers.
Okay.
One drives a Prius, one drives an SUV, and then there's my Aunt Martha. And the fixed cost that you're trying to collect is the gas station. Right?
Okay.
And the only revenue source you have to get that fixed cost paid for is the price per gallon. And the SUV driver is showing up every other day to fill up. Prius driver once a week, and then my Aunt Martha, who only goes to the grocery store and church. So she shows up about once a month to fill up her Oldsmobile Cutlass, just to put some flour. My aunt's not paying her fair share of, in your world, of the fixed cost of the gas station, right? Because she only she only shows up once a month to get gas. But you've decided to pick up the cost that you're missing on the gas station from the Prius owner. Isn't that what's happening here?
Yeah, but with all due respect, a gas station is not a really good comparison because it is a private, non-regulated industry. It's a for-profit.
Economically, it's the fixed cost of the gas station. I don't care about.
But
I don't understand why that matters.
but because you don't, cost causation is not a principle that a gas station or a restaurant needs. I mean, a restaurant or a gas station can discriminate in terms of economically on customers however it wants. In rate design, when you're looking at a regulated utility that's a monopoly, you have to factor in cost causation. And so...
Okay, it's a gas station. It's the only gas station in town, and it's regulated because, I think you're trying to if there's other ways to distinguish my hypothetical,
Okay.
or if it's just crazy, that's fine. But I don't think we can say that one's regulated and one's not. Because economically, you're trying to recover the fixed cost of the gas station through the price of per gallon. And you've only picked the Prius to charge more, as I see it. And that seems to support what these guys are saying.
Well, no, I think in your hypothetical, your aunt with the Cutlass is also probably is probably paying more because she's an inconsistent. Well, I guess she's consistent, but she's irregular. If a Cutlass, each
But
time.
you only decided to charge the Prius more per gallon.
Right. The aunt's paying less. She's paying less than the
The
Prius is.
the aunt is still, under our scenario, the aunt is still subsidizing the Prius driver.
Right.
So I mean, so what we're trying to do is we're trying to help. The system is trying to make it more fair for your aunt because the Prius driver is a free rider, where your aunt, even though she uses the gas station maybe more infrequently than the Prius driver, she's subsidizing the Prius driver. I don't know if that complicated things or if that kind of addressed your question.
But you don't recover, you only recover $15 or $16 of your cost. The cost of production, cost of connectivity to the grid. You've chosen to only charge, Justice DeGaulle was getting at, why don't you just charge $78, the cost of, charge your whole cost to everybody equally, and then make your profit based on usage above that. You charge 20% of your cost and get all the rest of your cost from everybody plus profit all out of usage, correct?
I mean, that you probably could do that. You would raise rates.
Isn't that what Westar does right now, is charge $15, you need to get to $78 a customer to make a profit, right?
Okay.
According to some of the testimony.
Sure.
You charge $15 to $18 in your flat cost. That's supposed to be the cost, but that doesn't cover your cost. You have to get from 18 to 78 by usage just to get to profit beyond that, right? So everybody's being, nobody's covering their cost of service, right?
Well, everybody's. I mean, and the residential customers are paying their cost of service under this system. The traditional residential customers are paying theirs, and they're paying
Because their usage gets them up over $78 a month.
Yes.
And some of them don't, though. Some of them use less. The Aunt Martha analogy is the electricity customer who just doesn't use much, right?
Right.
And you want to charge the Prius or solar
sure, but
owner more to cover not just those who use a normal pad, but isn't there less use just predictable and expected?
Well, let me give you an example, if I may, that ties back to Aunt Martha. That if I remember the hypothetical correctly, Aunt Martha is going to church once a week, and that's when she's getting gas. So if I run a gas station, and if there were still gas station attendants, or I need somebody there at the gas
once a
station.
month.
Okay, once a month, I'm sorry.
Right.
I, as a gas station owner, can properly staff the gas station. I can pay somebody by the hour to show up right after church that once a month, and I can keep my costs manageable because I know Aunt Martha is coming by the third Sunday of the month at noon. Versus,
So are you truly then arguing that the solar users all of a sudden have a peak demand between 2 and 7? All of a sudden, a bunch of solar users come onto the system, causing increased cost and driving increased cost to run the grid, demand on the grid, that all this extra cost comes in there? Or is it really about just they're using less, so we're subsidizing non-DG
they're using
customers?
less, and we're subsidizing them, but the peak hours of demand are 2 to 7 on weekdays, and that's when.
That comes from everybody, though, right?
Correct, but they're the ones that are the ones that throw the system off because they
throw the system off. Does that mean they're increasing the cost to Westar between 2 and 7?
Yes.
But don't you expect them to do that? Isn't that built in, or do you have to build it in now with what looks like a rate increase for solars?
It's not a rate increase for solars because their design is revenue. The classes are revenue neutral. So even if they had a two-part rate design, like everybody else, their rates wouldn't have increased. I mean, from that, I know that I'm getting.
Yeah, but then isn't the essence of all this that it's not, we're not really here to decide today whether or not this particular rate hike results in injustice to the present solars, because it may be a little bit more, some might pay a little bit more, some might pay a little bit less. This litigation is being driven by the fact that if they can do this under 265E and more solar people come onto the grid, then you can do different cost structuring to have them pay more in the future to subsidize the others.
I mean, that's the purpose of 1265E. As the Sierra Club said, 117D was enacted 40 years ago. That was before you had, solar power was really not in vogue 40 years ago. You didn't have residential self-generation. I think the legislature recognized, and I can go through the legislative history. I know I'm way over time, so I don't want to, but
You're getting down to it.
But that's what 1265 was designed to do, to modernize things, because 40 years ago, none of this was an issue.
Council, Jimmy Carter was putting solar panels on the White House 40 years ago. So I guess that leads me to my question. Doesn't this disincentivize the use of solar electricity generation?
It shouldn't. I mean, they're still not paying their full share of the capacity cost.
Well, we wouldn't be here if it didn't disincentivize, if they weren't being forced to pay more, right?
No, I mean, to me, the disincentive is that depending on your age and stage of life, a solar panel is still expensive, and you're going to save money on electricity, but it may take you 20 years.
Let me restate the question.
Sure.
Assume for the purpose of my question
Okay.
that this disincentivizes the use of solar by customers.
Okay.
Doesn't that run contrary to the clearly expressed policy preference of the legislature?
I don't think it runs counter to 1265, which legislative research explained that the bill was designed to remove a requirement that a utility must offer customer generators a tariff that's identical in
So you disagree with the premise of my question that the legislature has expressed a policy preference for increasing the use of renewable energy?
I think I just don't think there's a difference between, yes, the legislature has been pro renewables, but I think that's separate and apart from whether solar customers should be subsidized by the other members of the residential class.
Do you then agree with the Court of Appeals that the two statutes are irreconcilable?
Yes, Your Honor. And because
would you agree that the legislative policy that Justice Stiegel has asked you about is in 117D?
I think it is, but yes, but 1265, since there is a conflict which which the Court of Appeals correctly recognized, under general statutory construction rules, the newer and more specific 1265 controls, and this court hasn't heard any reason to ignore those general rules of statutory construction. There's a conflict, and you look at the newer, more specific statute, which is 1265, which specifically authorizes different rate structures, time of use, and all of that for solar customers and other residential customers.
Why can't we read them as being consistent? That you can have these different rate structures, but if you're going to do something different with respect to solar or these self-generating people, you have to lower their rate or advantage them as opposed to disadvantaging them.
Sure. I think all of the attempts that we've seen from the Sierra Club where they've tried to reconcile the statutes, they have read words into the statutes.
But I'm not asking about theirs. I'm asking a simple question of, if you look at the two together, why couldn't you read them together and say you can have a different rate structure for them, but it can't raise their rates as compared to other customers or otherwise prejudice or disadvantage them?
Because if you constructed it that way, again, not only are you adding things into the statute that aren't there, but
What did I add that wasn't there?
you're allowing them to prejudice every other customer.
But 166, the first statute, 117D, doesn't say anything about you can't prejudice others. It says you can't prejudice those who are producing from renewable energy sources other than nuclear.
Correct. So I mean, I mean, you're creating a system again where I don't see anything in the legislative history that is designed to say that we're setting something up where other residential customers have to pay more than solar users, and that seems like what that reading of 117 would do. It would kind of eliminate cost causation and make the typical residential class a disfavored class, almost.
Well, right. If you look at the legislative history, that was the gist of the push for the bill at the time was we're just not recovering enough money from DG customers.
Yeah, and so I think if I understand you correctly, 1265 was designed to
Recover more money from DG customers.
Yeah, yes.
If they could have gone and done something more direct, it would have been helpful. Probably not worth, maybe it's not worth looking back at, but they could have said 117D is now just a grandfather clause. If you were in before then, we can't charge you more, but going forward, we can. Instead of leaving it this, if there's a cost structure and usage patterns are fairly,
I think they
obscure it pretty well.
Well, I think they tried to grandfather. I mean, in 1265, they do grandfather in D&E the customers before July 1st, 2014.
Could have said they were doing that more explicitly.
They could have. There'd be, but yes, I agree.
Counsel, we've not given you much time to speak. Would you, in terms of your own argument, would you like 30 seconds to at least tell us what you would like for us to do?
Yes, that would be wonderful. As we were saying, there is a statutory conflict. It was correctly recognized by the Court of Appeals, and there's no reason to deviate from the general rules of statutory construction and recognize that 1265 is a controlling statute. Again, the Sierra Club is asking you to vacate the RSDG rate, which would exacerbate the problem of traditional residential customers subsidizing the DG customers. They don't offer any alternative that would eliminate or even mitigate the subsidy, and they've not presented any reason for this court to ignore traditional cost causation principles. Therefore, I would respectfully request this court deny the appellant's petition for judicial review and affirm the Court of Appeals' opinion, which upholds the Commission's rate design. Thank you, and I can take any more questions if you have them. Otherwise, I'll sit down.
All right. Thank you.
Thank you.
Mr. Bergman?
Good morning. May it please the court. My name is Martin Bregman. I represent Westar Energy, Inc. and Kansas Gas and Electric Company.
Was there any attempt on your part when you were advocating for the new legislation to deal with 117D and to at least try to recognize what it stood for and the policy that it stood for?
Your Honor, I don't have any knowledge of the lobbying that went on or the advocacy by Westar or any other utility with regard to 1265. I really couldn't answer that question.
Okay.
But it does seem to me that even based on the argument that was made by the Sierra Club today, that 1265, even as originally enacted in 2009, conflicted with 117D. Counsel for Sierra Club said that rates for DG customers could be lower than rates for residential customers. But 1265, as originally enacted, it would have been in subsection B at the time, said that the rates had to be identical. You had to provide exactly the same rate structure, the same tariff, the same contract for DG customers as for non-DG customers. So even as originally enacted, they weren't consistent. And then when the law was amended,
How would it be inconsistent as originally enacted if they're the same?
Because
Does
what-
it prejudice the solar owner?
What 117D says is that you can't prejudice solar customers. Counsel for Sierra Club said, and I think correctly, that 117D would have allowed a lower rate for solar customers than for residential customers.
But he was
1265D.
talking about the current 1265, not the one that you just
Well,
referenced.
the current 1265 isn't any different from that, because 1265D picks up the same language that was in 1265B and says that for customers that were distributed generators, DG customers, on or before July 1st, 2014, that their rate had to be identical in every way. The same rate, the same contract, the same tariff, had to be identical. And that goes back, that language was in the bill, the law passed in 2009 and kept in 2014, just moved to a different section. So if 117D always allowed lower rates for residential, for DG customers, and 1265 says they have to be identical, that right there is an inconsistency.
Do you agree that 117D actually doesn't say anything about whether you can have a lower rate for solar generators?
I agree with that, yes.
Okay. So
I'm
if
simply
you have
saying-
identical rates for everybody, how would it conflict with 117D?
It would not.
Okay.
That wasn't what the counsel for Sierra Club said.
Okay.
There's also a question about whether or not the rates for DG customers are necessarily higher than rates for residential customers. And I would point out that the commission actually addressed this in their order and talked about the fact that there's a point at which what they said, and this is at the transcript volume 29 at page 310, at the point where an RSDG customer would be using about the same amount of energy as the average RS customer and have a demand lower than 5 kilowatts, the RSDG customers would pay less under the DG rate than he or she would under the RS rate. And the commission also found that there wasn't any evidence in the record that shows that customers weren't capable of taking service under those circumstances. So the rates are not, you can't directly compare them because the structures are different.
Counsel, can I just go to the briefs on the point you just mentioned?
Certainly.
In the brief originally filed by Sierra Club at page 5 and 6, they said it's undisputed in the record that solar customers with their actual loads and energy use will pay more under the RSDG rates imposed on them than they would under the RS rates available to non-solar customers. They cited to specific record volume 24, 145, and 146, which was the specific study mentioned by Ms. Yozwiak. In response to that, in your brief, you cited the same thing you're citing now,
Yes, sir.
which is just the point that from the commission's findings, an individual customer might lessen their load, and depending upon how much they're actually using, some individual users could end up paying less. But that doesn't seem to negate the statement that was made or the overall idea that this has to be overall causing solar people to pay more unless they substantially change their usage. Otherwise, there'd be no point in doing this.
I think that over time, that's correct, that the idea was to have the DG class pay its fair share of demand costs, which they do not do under a two-part rate.
Which means paying more than they currently pay. To get a fair share, if you're saying they don't currently pay it, and this is designed
Yes,
to get it.
and that, it's our position that that's allowed under 1265E, and it's also consistent, also allowed under the federal regulation 18 CFR 292.3.
There's clearly a dispute about the law. I understand that. I'm trying to get the factual point, which is factually there's this claim that solar users wouldn't be paying more based on the single finding that an individual solar user could reduce their usage and thereby end up paying less than they do now.
I think
with the new rate
on a class
structure.
basis, the rate would be somewhat slightly higher for DG customers currently than it is for RS customers. And what happened was, as counsel for the KCC indicated, when the class was set up, and this is in Dr. Glass's testimony, he made that, he set the original rates to be revenue neutral, so that the rates for the DG customers and RSDG customers would generate the same amount of revenue. but the rate decrease that was applied to those different classes, was different. There was a larger decrease for RS customers than for DG customers. So yes, the rate on an individual basis would generally be higher.
Okay, so the statement from Ms. Yazwiak's testimony is not rebutted in the record, that overall, the solar users will end up paying more under this new plan, if with current usage rates.
That is correct.
Okay.
But as a matter of law, under 1265E, that rate is lawful.
But if we were to conclude that 1265E does not negate section 117D, would it not be a conclusion then that this rate structure can't be allowed? If you only had 117D at issue, 1265 never existed.
But
Would you agree that this would violate 117D?
yes, but
Okay.
our view is, and I think it's very clear that 1265E is completely inconsistent with 117D. And if you look at there's been a lot of discussion about having some kind of a rate design for all customers that would address this problem. And the fact of the matter is, the Commission has long had the authority to establish demand charges, minimum bills, time of use rates, any other kind of rate, forever. I don't think there's ever been a time when the Commission didn't have that discretion.
Can you say which of those this is? The 1265E talks about the three types of rates: time of use, minimum bill, and then other rate structures.
Well,
Is this one of those?
Counsel for the KCC suggested this is a time of use rate, and to some extent it would be, because the demand charge is assessed based on the time of day. But it also falls under the other. I mean, other obviously encompasses just about anything you could do, I believe. I think that was the legislative intent, was to give the Commission, to continue the Commission's discretion to design rates.
Does Westar have a position about which of those things it is?
I've been putting it in the other category, but I certainly wouldn't contest the KCC's argument that it's a form of a time of use rate. There is a time of use variable to it, because the demand charge is only assessed on usage between 2 o'clock and 7 o'clock on non-holiday weekdays.
Can I ask you about usage?
Certainly.
My understanding is that the heart of the economic claim being made by the utility and the KCC is that certain usage behaviors create a free rider problem on the system. Would you agree with that?
Yes.
So my follow-up question then is, why can't you design a rate that applies across the board based on usage behavior, as opposed to creating a rate that applies only to customers that utilize renewable energy production?
Well, you could do that. There's no question that you could do that.
So why not do that?
Well, there's a number of reasons. One is the two-part rate has been in effect on this system and basically really across the United States for residential customers as long as there's been regulated utilities. It's something that customers are familiar with, and
So you're just saying it's too hard. It's too hard to do.
but that is a large part of it. But the fact is, of course, that under the case law in this state, the Commission has wide discretion to make decisions on rate design.
I'm
And
just
one
trying
of the things that it considers, among the factors that it considers, are familiarity, stability, cost causation. Obviously, is one of those things. But we have a class here. The residential class on Westar system is somewhere in excess of 500,000 people.
Yeah, let me just
The
simplify
DG class
this.
is only about 700 people, and most of them are grandfathers. So this rate only affects about 350 people.
But let me just simplify the question. Let's grant for the purposes of the question that your argument is correct, that the way it is now, there's an economic free rider problem. And you can design a rate structure that solves that problem in a way that doesn't violate 117D, and you can design a rate that solves the problem that does violate 117D. Why choose the one that violates 117D when you have the option of solving the problem in a way that doesn't violate 117D?
Because we had because we had KSA 661265E, which allows us to create this rate for DG customers only. I would point out that 1265 only deals with rates to DG customers. It doesn't talk about rates for everybody. And it says in D it says that the rates for DG customers have to be identical in every aspect for the rates for non-DG customers. And then E says, but the utility can, in an appropriate rate proceeding, establish rates based on using minimum bills, time of use, or other rate structures. And the clear implication of that is that what's prohibited is in D, what's allowed for DG customers is in E. If the legislature merely meant that the commission could establish time of use rates, minimum bills, or other rates for DG customers, why did they even bother to enact the amendment? Because the commission always had that authority. That interpretation renders 1265E a nullity, and it requires the implication of additional language that says you can put these rates in place as long as you don't disadvantage DG customers. Those words aren't there. The commission always had that authority. And so the attempt to harmonize these two statutes has to fail because it wipes out the later enacted, more specific statute.
Council, if we agree with your interpretation of 1265E, and just looking at the facts of this rate structure and trying to get to the resolution of the settlement agreement, et cetera, it comes out fairly close. Some DG customers are going to pay more, and you argue that some would pay less. But that's currently, in making the free rider or subsidization argument, we're currently at just a few hundred customers we're talking about. This isn't about those few hundred customers. What happens, it's about what happens when solar goes from less than 1% to 10%. If it goes there, don't you then have to charge those DG customers a lot more? Isn't that where that ultimately goes? Then you end up with a whole grid of, you end up 10, 20, 30%. You end up with a whole grid of free riders that you then have to charge a lot more to subsidize those poor folks who haven't gone to solar yet.
That may be the case, Your Honor. If we don't, one of the reasons for putting this rate in place today is because there are so few customers that will be affected by it.
Right.
There's only 350 at the time of the hearing.
They can't be putting that much demand on the grid. This is about future ability to.
Well, there was an expectation that this class would grow at a rate. I think we're growing at a rate of about 72% per year, and we expect it to continue to grow. Now, obviously, that rate of growth is likely to slow as you get more saturation. But if you don't put this rate in place, then what happens is that the utility suffers a loss of revenue recovery because of lost sales, but it still has to build to meet its generation facilities to meet peak requirements, and the record indicated that these customers. Westar witness Faruqi testified that while these customers reduced their usage by about 50%, they reduced their peak demands by only 4 or 5%. Mm-hmm. So
So they're being charged more for placing less demand on the system at non-peak hours.
They're not reducing their peak significantly. They're reducing their energy usage by much more. And as long as the cost of the fixed costs are basically the cost, the investment to meet that peak. Right. Generation, transmission, distribution. Those don't change when people use less energy as long as the peak doesn't change. And so if customers are using less, we need this demand charge rate helps folks that are able to reduce their energy needs without reducing their peak pay their fair share in the system. If you don't do that, then those costs are going to get picked up by the other people that can't reduce their rates, right. Unless you change the rate designs. which
end
would
up
be
back-
highly disruptive
Right.
and would require a tremendous amount of
Don't you end
re-education.
up back in Justice Biles' scenario where the non-peak users, you're going to end up charging more to the Prius user and less to Aunt Martha, who actually uses even less?
Well, the difference though is that electric customer, the utility has an obligation to serve every customer. And the analogy is imperfect for one simple reason, which is that unlike Aunt Martha, electric customers purchase their energy the moment they need it. They don't buy it on Sunday or the first of the month and then use that energy all month. They buy it, and the company has the obligation to manufacture it at exactly that instant. The utility business is an amazing business. It is it's the most extreme example of just-in-time manufacturing that there is. The utility company has to generate electricity for all of its customers and has to match its generation to consumption within a very narrow band, 24 hours a day, 7 days a week, 365 days a year. It's not a gas station, and the analogy doesn't work for that very reason. And when these solar customers move up and down, a cloud passes by, and all the solar generation goes away. At 5 o'clock in the afternoon on July 21st, Westar has to ramp up generation to meet that lost generation that occurred. And if we can't charge the solar customers for their peak demand when those things happen, and they're going to happen, then everybody else is going to pay for it. And that's just not fair. And I think that's why the legislature made the amendment to 1265 in 2014, so that rates could be designed to meet those kinds of requirements. And similarly, even the federal regulation and the federal statute does not prohibit this. 18 CFR 292-305 was authorized by 16 USC 824A3 sub C. It's a lot of alphabet mumbo jumbo, but that's the statute and the regulation. Both state that rates for sales by utilities to QFs, which includes qualified facilities, which includes DG customers, have to be just and reasonable and can't discriminate. In American Paper Institute versus American Electric Power Service Corporation, 492 U.S. 402 at 415, the Supreme Court discussed the language of the statute. And discussing that language, the court stated that there was a passage in the House Conference Committee report that explicitly states that the just and reasonable language of that section, which concerns sales by utilities to qualifying facilities, is intended to refer to traditional utility rate-making concepts. In other words, as long as rates are just and reasonable, that is, they match cost causers to cost payers, and don't discriminate, that is, they treat similar customers the same and different customers differently, they're okay.
Thank you,
So-
counsel.
That's what the statute means, and our rate meets those requirements.
Are there other questions?
I have one, and I hope it'll be really quick. Just to clarify for my own mind. Your argument is that because of the inconsistent usage, the utility incurs higher costs. So if tomorrow all the solar generating customers just dropped off the grid, what would be the cost savings to the utility? Just so I understand. Would it be in payroll? Like, what would the actual cost savings to the utility be? Is it that the utility wouldn't have to hire as many people to work during peak hours or maintenance?
It's hard.
I'm just trying to understand.
I'm not sure what it would be because
Well, your argument is that this imposes extra costs. So it seems to me like if I take away the problem, you would be able to articulate to me what the cost savings would be.
Well, the immediate cost savings would be very small because 78%, I believe, was the number shown in the record of the utilities' costs were fixed. And what
But
we're
your
really
whole
talking
argument-
about is investment in physical investment, the fixed costs are the investment in generation, transmission, distribution, on which the company earns a return and for which it borrows money and for which it's issues
Okay, well,
stock
that's
to pay
different
for.
from what I understood you to argue, which is that the inconsistent usage pattern creates elevated costs.
I don't think that was what I argued. What I'm arguing is that because solar customers' peak demands don't change significantly from what they were before they put in solar panels. Dr. Faruqi indicated they only went down about 4% while their usage went down 50%. And other customers' demands are going up at the same time. So the cost of meeting demand by the utility doesn't change significantly when customers install solar panels on their roofs. And I also when I mentioned to you, we incorporated there was a generic docket at the commission before this rate case, and that generic docket was incorporated into the record at the KCC. One of the things that we found the commission found in the generic docket, and there was testimony by one of the installers, is that typically when solar panels are installed, they're installed if there's a south-facing roof they use a south-facing roof. And the reason they use a south-facing roof is to maximize the amount of energy they generate. Not if they wanted to maximize the amount they generated at peak periods, they would install on a west-facing roof. They don't do that unless they have to.
Other questions? Thank you, counsel.
Thank you.
You reserve 5 minutes for rebuttal.
Thank you. There is a lot there that I'd like to respond to, and I only have 5 minutes. But one thing I'd like to do is dispel this this claim that solar customers, that this RSDG rate is somehow designed because solar customers cost more because of their variation in use during high cost hours. Number one, that's not the basis for the rate. The RSDG rate is premised on the idea that solar customers and non-solar customers have the same demand costs, not that solar customers impose more. And that was explicit in Dr. Glass's testimony. In fact, if we look at the peak cost causing hours, the ones that were given as examples, the peak afternoon during summer, those data are also in the record, and it's in our brief on page 17. If you look there, it's not that solar customers have higher use. Solar customers are actually reducing their use by between 6 and 60% during those peak hours that were used to determine costs for generation, for transmission, for distribution. In addition, I wanted to address the Aunt Martha hypothetical. I think that hypothetical exactly captures this issue, which is for economics, it's no different for the gas station. It'd be no different from McDonald's. There are a bunch of fixed costs that go into the system, and there has to be a policy choice on how we're going to price product to recover that. And a customer who uses those fixed costs less frequently will pay less towards them if we charge based on usage. And that's true universally across solar customers and across other customers. The problem with the rate here is that policy was changed, but it's only changed for solar customers. There's a different policy applied to solar customers saying that pricing system based on volume of usage should not be applied to these customers. We want to apply a different policy to those customers. And whether or not that policy writ large would be a good policy or not isn't the issue here. The issue here is you can't choose to apply it only to some customers who use solar and not apply it to others.
If the utility wanted to create a sliding scale where the first 100 kilowatt hours costs a lot more than the 10th 100, and it would apply equally to everyone, you wouldn't have a problem with that, would you? Even though it would end up causing solar customers to pay more, but the rate's applicable to everyone.
Yeah, so that's referred to as a block rate or a tiered rate. And I would say, I'm not going to say that my clients would have no problem with it, but they would. The issue wouldn't be.
It wouldn't be discriminatory.
It wouldn't be It would not violate 117D or 305 or 292-305. Right.
What's your response to Mr. Brigman's argument about why 1265 necessarily negates 117D, because he says that it requires equal rates and therefore wouldn't let you have lower rates for a solar user?
Yeah, so I'm going to admit I didn't quite follow his argument, but as I understand Your Honor's question, the 117D says no higher rate, no prejudice. 2009 legislation said for a subset, customers who are customer generators, which is, let me be clear, not the same as all customers with solar. It's customers with solar who choose to take advantage of net metering. For those customers, the charge needs to be the same. There's no conflict there, right? That the same is not higher, right? Therefore, no conflict with 117D. And then when that changed in 2014 and said for customers signing up after 2014, if the legislature had intended to say you may charge higher rates, one would expect that to be in 1265E. And that's the 1265 sub D is for customers before 2014. E is for those after. It says before has to be the same, and then in E, and the problem with respondents' argument all along has been it's reading into that something to make it the mirror image of D, to say you may charge higher rates. The problem is that language isn't in the statute. It's omitted. In fact, E only talks about rate structure. It says nothing about levels of rates, meaning the legislature didn't intend to authorize anything about levels of rates in that section, which means there is no conflict with 117D.
Other questions? Council, we gave you other council considerable time. I would give you a little bit extra if you'd like to summarize and make any other point that you failed to make in your rebuttal.
Thank you, Your Honor. I appreciate that. And I would just summarize to say this, that the Court of Appeals interpretation relies on it finding a conflict. And we would suggest to the court, if you look at the plain language, there is no inherent conflict there. It's certainly capable of being interpreted to avoid the conflict. In addition, the Court of Appeals applied the federal regulation, 292-305, to incorporate only one requirement, a cost of service basis. The regulation on its face has at least three requirements. Yes, a cost of service basis is required, but it doesn't stop there. It says it also must be consistent system-wide costing principles, meaning how we're going to translate cost of service into rates has to rely on consistent policies across solar and non-solar. And it says that even with those two conditions met, a rate can only be applied to a solar customer to the extent that it also applies to other customers, meaning non-solar customers, who have similar costs and usages. The RSDG rate, in this case, trips over both of those, that second and third requirement, in addition to violating state statute 66-117D. For those reasons, we ask the court to reverse the Court of Appeals with instructions to vacate the RSDG rate. Thank you.
Thank you, counsel. Thank you to all counsel. We will take this matter under advisement. At this